There we go. Very good. Okay, we are on YouTube Live and we are recording as well. I need to tell the participants that good morning. My name is Judge Bonnie Rangel. It is my honor and privilege to be judge of the 171st Judicial District Court. We are now 6/25/2020, 9:02. Of course, everybody knows we are in the midst of a pandemic. The Texas Supreme Court has allowed us to hold hearings via Zoom and YouTube Live. If there's anyone participating in this Zoom hearing that objects or does not want to proceed due to the limitations of both the YouTube and Zoom, please verbally let me know right now, verbally object right now. Let the record reflect that there is no objection. I want all the participants to know as well that Ms. Anita Garza is my court reporter participating in this hearing, as well as Rebecca Gonzalez, my court coordinator, and Mr. Rick Salazar, my bailiff. We are recording, as I've told you, to YouTube Live to comply with the Texas Open Courts provision. There is to be absolutely no recording by either the participants or by anyone looking at and watching through YouTube Live. If anybody does record, I can hold you in contempt of court. Remember, the only official recording, of this proceeding is the official court reporter's record. Now, last instruction, you have an options bar at the bottom. If you want to chat, if you want to go to a breakout room, I have no problem with that. Just please ask me for permission and I'll be more than happy to grant it to you. Now, with all those instructions and all of those disclaimers, is there anyone participating here today that does not want to proceed? And please verbalize that to me right now. Let the record
David, no problem, Your Honor.
Thank you, sir. I appreciate that. Thank you, sir. We are going to begin. Now I want the record to reflect that there was no objections. The first one is Adam Maschek, public defender. I don't think we have a public defender here, do we, Miss Becky or Mr. No, we don't have
No,
a
I don't see public defender.
No public defender. We'll get back to that one. The next one is Raul Carrera. That's Mr. Carmona. I let Mr. Sebastian Nunez in. At this time, court calls cause number 2018-3972, 2019-6271. Announcement of council, please.
David Nunez for the state, Your Honor. State is ready.
Sebastian Nunez here on behalf of Raul Herrera. Ready, Judge?
Good. Okay, so I think we need to proceed on a contested revo on this one.
Yes, Judge.
Right?
Yes, Your Honor.
I think we're going to. What was the recommendation? We don't need to go into the substantiation of the revocation. I remember this case and its ugly facts. Did you make an offer to settle?
Your Honor, I believe the offer was 10 TDC.
Okay. Okay, and of course, I don't even have to ask you, Mr. Sebastian, you're not going to take that.
No, Judge. Judge, and I think there were issues with regards to the case. We did have our investigators subpoena some records, which I think they were sent to Mr. Nunez. I just think he had issues opening up the file. I'll go ahead and resend those to him. We subpoenaed our client's Facebook records, which we did want to bring into your attention. I guess we did want to ask you whether or not you'd consider signing off on a subpoena of her Facebook records, just because there were some contradictions with the subpoenas that we received and what she's alleging. With that being said, Judge, we do intend on, filing a subpoena for her Facebook records. And based off of what those show, we would like to, at that point, maybe hopefully get into, I guess, a subpoena for the records from where the messages are actually coming from.
Well, see, this is my question, Mr. Nunez, Sebastian. Educate me a little bit. Remember, I'm old and a bit computer illiterate, even though I'm a Zoom expert now. I'm a Zoom expert. So don't let that fool you. This is my question. Can everybody mute? Because I hear noise, unless it's coming from you, Mr. Sebastian. all the Facebook records is going to give you everything, all messenger messages. I mean, everything. All you need to prove, I think, is IP addresses to see who posted what to where.
Exactly. Just so, and I think when we subpoenaed our client's Facebook records, it essentially showed that our client had blocked the complaining witness on January 1st, I believe. Those messages that the complaining witness is stating, those messages came after that time. We would like to see, I mean, at that point, our client was in jail. I mean, when those messages came. So, you know, unless our client called somebody from jail to delete that Facebook account, well, then, you know, then sure, there may be some reliability. But with that being said, Judge, I mean, the way the time frame is working, the way the timeline is working in terms of when she's saying she got those messages and when our client actually blocked based off of what the subpoena shows, then sure, there is in fact some contradiction between her statements and what actually really happened. So I think subpoenaing her records or her Facebook records to see where those messages are actually came from, and then finding the IP address for that specific account, that's the only way we're going to come, I guess, get to the bottom of where exactly those messages came from.
You know, to cut to the chase, Mr. Sebastian Nunez, to cut to the chase, there was a picture that was sent allegedly from him to her. It was him and his girlfriend. Remember
Yes.
that picture? Okay. And that was sent to her through Facebook, I think Messenger, right? Okay. How could she have gotten that picture?
Well, we don't
If
know.
you're
Judge.
saying, if you're saying somebody, she hacked it or if we can find the origination of just, this is my next question. If we can find just the origination of the IP address of where that picture was sent to her Facebook, wouldn't that solve the problem? Wherever that picture was sent from is the person that.
Well, exactly, Judge. And I mean, I think nowadays, and I'm not saying this is exactly what happened, but I think nowadays it is easy to, you know, create a Facebook account and put my client's profile picture on. You know, when we subpoena the records from his account, there was no indication that he's ever sent messages to her, which is why, you know, that's the point of me bringing up that she was blocked on Facebook since January, since before those comments actually came out, and she hasn't been unblocked since then, which just kind of goes to show that, you know, in our opinion, there is contradiction, which obviously, I guess it goes in favor of us, you know, denying the offer of 10 TDC. We just obviously aren't in agreement with that. And I don't think we're going to start talking about negotiations up until and if you are willing to sign off on a subpoena for her Facebook records, just because that's the only way we're going to trail, I guess. And, you know, and I'm not asking for a subpoena for all her Facebook records, but I think at least the time frame from when those messages at least came in.
If we can pinpoint, I think Mr. Martinez wants to chime in.
And Judge,
You know, Your Honor,
I don't know, did you ask Mr. Nunez if he waives his client's presence since he is in jail?
Thank you. I forgot to do that. Are you waiving your client's presence for this hearing? Thank you, Miss Becky.
Yes, Judge.
Okay. Yeah, halfway into the darn hearing. Sorry, I forgot, Miss Becky. Thank you so much for reminding me. Okay, I have privacy concerns regarding her Facebook records. So I think we need to give, you know, I have privacy. This is what I'm looking at. I have privacy concerns regarding her Facebook records, but you're looking at 10 years and he did some pretty bad stuff. If he did it, all those messages, all of that is pretty bad. So you should be entitled to try to prove your case is what I'm thinking at this point. So how can we do it so we can kind of address those concerns and not invade her privacy? Weren't some of these messages sent through text form as well, not just Facebook Messenger, or am I remembering wrong?
No, they were just via Facebook Messenger, Your Honor.
Okay.
You know, what I was thinking we could do is we could submit a court-ordered subpoena to Facebook requesting the origin, the IP address, you know, cell phone number of these particular posts.
That's a great idea. That's a great idea. Mr. Sebastian, what do you think? I think that's great. And we'll get it straight from Facebook.
And just to clear up, Mr. Martinez, are you saying just the subpoena, I guess the records or the IP address of where the messages are coming from specifically to the complaining witness?
Yes, each specific message though, to itemize it in each specific message. I think that's a great idea.
Yes.
So that way we're not turning over any private messages or anything.
Right, right. And it's not just the wholesale, we want everything
Right.
regarding her Facebook accounts.
Right,
No,
right,
it's
right.
just the origin, IP address or cell phone number of the
Mr.
particular.
Martinez, for once in his life, has come up with a fabulous idea. That was great, Mr. Martinez.
Right, yeah, and then we'll craft something, get the wording down, and then we'll submit it to the defense
Great.
counsel.
So this is going to take, this pre-revo is going to take at least more than 45 days by the time you craft the order.
Mhm.
I sign it, Facebook gets it, complies with it, and sends you back the info.
Right, my
Okay.
experience with Facebook and Google and all those companies it's not
Is-
fast.
Not fast, okay. Okay, can we set up a revocation in about 60 days? The actual contested revocation in 60. If you haven't heard from Facebook, then, okay, we have to.
Right, I mean, obviously, we'll know, hey, if it's
Right,
20 days before the hearing and we haven't received
Right.
anything, then.
right. So I'm gonna set a contested revo in 60 days. Okay,
Perfect, Judge.
very good. Anything else, Mr. Nunez?
Nothing further as of right now for this case, Judge. I am covering a case for Felix Valenzuela, though.
Okay, I'll go ahead and take that up next so you can leave.
Thank you,
Anything
Judge.
else, Mr. David Nunez?
Yes, Your Honor. In regards to those messages, they were not sent while he was in jail.
No, and I did misspeak on that. Sorry, David.
Now, that being said, Your Honor, we actually, when we spoke with the complaining witness herself, we actually found that same profile where the messages were coming from. In that profile, within those pictures, shows the defendant in this case with the CW of the injury to a child. And we're talking about photos dating back to at least 2018. So, Your Honor, we would have to literally believe that if they're claiming that the CW faked a profile, we would have to believe that she faked it all the way from 2018 just to turn it around on him to this point.
Would all
Or,
those pics,
or
would
of
she,
course, second to his-
okay, in that profile that you tracked it to, where there's postings up to 2018, were those pictures, et cetera, that she could possibly have had access to?
Yes, absolutely, Judge. She could have copied and pasted it, but from what I see, and I didn't go through all of them, there was no picture of the girlfriend, the blonde girlfriend and the defendant. But I just wanted to let the court know of that. And like I said, you would have to believe that either she faked it all the way from years ago to turn it around on him now, and be a victim of these crimes that he was convicted of,
So,
or that she hacked into it.
so that 2018 Facebook that you tracked all these messages to, who's the IP address under?
It doesn't. I'm sorry, Your Honor. I don't.
Okay, it has an IP address. Everything has an IP address on the internet. So what's the IP address of that Facebook account where it came from since 2018, that has posting since 2018?
I don't have the address, Your Honor, but what I'd like to do right now is, Your Honor, I'd like to email yourself and Mr. Nunez the photos. That you can maybe take a look at them. I have them already ready to go right here, Your Honor.
Yes, do that. These are the photos on that Facebook that was the origination of all these messages, right?
Yes.
They're not. It's not the original. It's the profile where the messages allegedly came from, Your Honor.
Right,
But
that's what I'm saying. That's what I'm saying. So that has to have an IP address, and the IP address has to have a name and some identifying info.
and Your Honor, right after.
That's my question. That's why you need to get a computer guy to track the IP address.
Well, Your Honor, as soon as these allegations came out and the defendant was arrested, very shortly afterwards, this account was deleted.
And I mean, I believe the IP address could still be tracked down, Judge. I mean, I don't think there would be any issues with the subpoena.
Okay. I've not gotten the pictures yet. Have you, Mr. I'll look at the pictures. Okay.
Which is what goes back to say, Judge, which is what I had mentioned. The client, and correct me if I'm wrong, David, but our client was in jail when the Facebook was deleted, is what we're saying.
Correct. No, yes, that is correct, Your Honor.
And I think that's what I had misspoken to with regards to.
He could have very easily, hey, bro, you better hurry up and delete this Facebook. It's going to
Sure,
cause you a
Judge.
lot of problems.
And
Yeah.
it's just
please.
easy, and it's just as easy for somebody else to create a Facebook account, Judge.
But if
I mean,
there's,
I don't
there's
believe that.
information in that account that is the sole custody and possession of defendant, there's a lot of problems. You'll have problems, right?
We get that, Judge. I think we're just of the opinion that, it's hard for us to believe and get behind the fact that our client blocked her, which the subpoena shows that our client blocked her on January 1st, and then creates a Facebook page with his exact same profile picture, and then sends her a message right after that, knowing very well it wasn't allowed. And
Because those messages are ugly. He doesn't want to be identified in any way, shape, or form. That's why
he doesn't want. But Judge, if he doesn't want to be identified, then why put his own profile picture? Is what I'm saying. Which that's what we're saying. We're saying, why does he block her on January 1st? Then days down the line, creates another Facebook profile with his own picture.
Why? You know why? You know why, Mr. Sebastian?
Yes, Judge.
Because criminals are stupid. Why do they get on Facebook and start gloating and blow about novias, about crimes they committed, and they're sitting there gloating and on Facebook because they're stupid. That's why. So no, you're right. It's logical to you. It's logical to me. It's logical to Mr. Nunez, to Mr. Martinez. But that's why people go on Facebook and gloat about the girlfriends they have when they're married. They gloat on the crime that they committed, and they brandish guns and they brandish knives, and they're felons. Simple stupidity. Now, you don't want to believe your client is stupid. Okay, that's a whole nother story. But I can see it happening very easily because I think it did. But let's see. I'm giving you every opportunity. And you don't think you need a computer expert? No, you think you're okay with just tracking and IPs and all that stuff, Mr. Sebastian?
I mean, I think it would be good to have, a computer expert to track the IP address.
I think so. To give us some kind of a background info. Your guy's looking at 10 years TDC, and what he said was pretty bad stuff. I can't get the pictures. Oh, I see it. He joined October of 2016 is what one of these pictures said, R.A. Herrera. He joined October of 2016, Did you misspeak and say 18 or did I hear wrong?
Your Honor, I misspoke. I know one of the photos that I sent does say 2018, but I must have missed the little subsection where it says that he's been active since 2016 on Facebook.
Yeah, it says 2016. Okay. All these are on that Facebook account, and that's been deleted, is what you're saying, right? All the pictures you sent me?
Yes, Your Honor, that has been deleted. And that was very shortly after he was arrested.
Were these people together? Was this complaining witness and Mr. Raul Herrera together in April of 2018? Does anybody know?
I could not tell you. But Your Honor, I do know that the complaining witness, I'm fairly certain she's watching right now. And if, I'm more than willing to let you ask her.
Oh, well, I can't get to YouTube Live. Well, he's posting pictures with it looks like they're together. It looks like they're together. November 24th, 2018. Yeah, it's Christmas time. He has his beautiful little daughter. So it looks like they're together that time. If that's the case, that's a worst case for you, Mr. Sebastian. Not a good case for you. Okay. The notepad stuff that you sent me, I'm not getting anything on. You
Those
sent me
little The ones that say att.text, Your Honor?
No, let me see. I thought I did an image.
Oh, yes, there should be 4, Your Honor.
4 images, 2, 3, 4 images. What are the ATT, the notes?
Yeah, that's nothing, Your Honor. I think that's just comes with the uploads, but it's
Oh,
nothing.
yeah, because it's blank. No wonder.
Yes, Your Honor.
Okay, it's blank. Okay, Mr. Sebastian, these look like, yeah, April 2018. See, Mr. Sebastian, this is another problem you have because this was during, I would say, a time that he was at least getting along with, I don't know if they're married or not. I don't know what their legal status is at this point. I don't, are they married and divorced, Mr. Nunez, or what?
I don't believe they're currently together right now, Judge.
No, what,
I can
what's their
legally.
legal status? What's their, were they married at one time?
Yes.
Oh. They were married. Okay. This looks like happy times when they were married. That's what these pictures look like. In which case, it could very well be his account. I think you have a you're harder pressed. If these are the accounts, all that ugly stuff came out of, he posted lots of pictures during happy times, right? So for you to say that was a hacked account or somebody created it or something, that's what I'm trying to say, Mr. Sebastian. You're gonna have a hard time with this account, but you guys are great attorneys. Great attorneys. I'm very happy that Mr. Raul Herrera has a great attorneys because he's facing 10 years TDC as the offer. I would offer a little bit less, Mr. Nunez. No, you want to stay at 10 years, or the complaining witness says 10 years, or
I'd like to reach out to her.
I'm sorry.
I would like to reach out to her and
Okay.
discuss it, but
Before all of this happens, I think it is a time wreck. I think in my book, Mr. Sebastian, but give him a rock bottom offer that you'll take, so all of this doesn't have to happen, right? And everybody will be okay with it. Let's try to do that, okay? But then if that doesn't work, then you all have to get together, craft a very specific order to Facebook so that all of this can be done. But I'm just telling you common sense. Mr. Sebastian Nunez, looks like this was his account. This wasn't a hacked account because there were good pictures, good times. Okay. Okay, I gave you my 2 cents, Mr. Sebastian. You have work to do.
Thank you,
And
Judge.
if he talks with his client and they can come up with a number
Okay, make a
that they
counter.
think is right,
Make a
and
counter.
then we'll, like Mr. Nunez said, we can go to the complaining witness and we can discuss it.
Okay, Mr. Sebastian, if you can talk to your client and see if he's willing to make an offer, whatever it is, let the know, please.
And just to be clear, Judge, on the subpoena, you know, and I'll talk to my client, but is there, you know, we still would like to go through with the subpoena. Is that something that, you know, we can start prepping and then send to you, Judge? Or
A subpoena if you have that order directly to Facebook, ordering them to, right? We don't need a subpoena if we have an order directly to Facebook saying, Facebook, you better produce A, B, and C.
okay.
Okay,
Judge, I mean, that's the point. I mean, my understanding was you were trying to get us to work out this case without going to the whole subpoena and
I mean,
all that process.
and I get what you're saying, Mr. Martinez, but at the end of the day, I mean, we still have to do, you know, what's in our client's best interest. And
Okay.
what we do know for sure is that we still want a contested rebel. With that being said, I mean, I don't know whether or not he's going to want to take a deal right now. We haven't spoken to him about it. The last time we spoke, you know, I think just because, you know, it's being recommended that we try to work out the case, that doesn't necessarily mean that we still don't want to, you know, prep the case and see, you know, what our options are. Because if that subpoena comes back and it's in our favor, I mean, without a doubt, we're not, you know, we want to head straight into a contested rebel. You know, and that if that's something you guys aren't willing to do, then, you know, we completely understand. But I think our stance is still trying to get that subpoena out or the order to Facebook.
Okay, that's fine. Yeah, we'll work on that. But I guess we'll just, you know, we'll just stay with the 10 for the time being, and then
Okay.
in the meantime, we'll try and craft a an order that we think will be responsive to what we're trying to get here.
Sounds good to me.
Great, thank you. Anything else, Mr. Sebastian?
Nothing further, Judge.
Mr. David?
No, Your Honor.
Mr. Martinez? Anything else?
No,
Mr.
Your
Martinez?
Honor.
Good, thank you. You may be excused on that one. You're covering for who else, Mr. Nunez,
Felix
Sebastian?
Valenzuela, it's an arraignment pretrial on Mr. Trader,
On
Colonel Trader, I believe.
Colonel Trader. Oh, there it is, Colonel Lee. At this time, for cause number, it's a status arraignment. Yeah, it's a status arraignment. 2020-0015, is it Texas versus Colonel Lee Trader? Announcement of council, please.
David Nunez for the state, Your Honor. Please ready.
Sebastian Nunez here on behalf of Felix Valenzuela for Mr. Trader. Ready, Judge?
And will you waive Mr. Trader's presence because he is in jail, Mr. Nunez?
We do, Judge.
Oh, thank you very much. Now, he was just found competent. Did you know that Mr. Valenzuela had filed a competency?
Yes, Judge.
And did you know that he was found competent
Yes, Judge.
recently? Okay. Okay, so do you know Mr. Valenzuela is going to contest that competency?
You know,
or-
and I don't believe so as of right now, Judge. I think Mr. Valenzuela just wanted to see if he could get a recommendation from the states, if there is one, and just talk to his client with regards to that and see what, I guess, how they want to proceed.
Very good. Mr. Nunez?
Your Honor, there is no recommendation at this time. We have not reached out to the complaining witness as of yet. I have made that request. So by today, hopefully we will have made contact with her. And I believe, if I'm not mistaken, he is enhanced. He has been convicted of an ag sex assault, and this is the, another first degree, facing a lot of time.
Okay,
If convicted.
I didn't catch half what you said. Ms. Garza, did you?
No, ma'am, it was a little muffled.
Yeah. You were coming in every other word.
Okay, Your Honor. Can you hear me better now?
Let's see, keep talking.
Okay. There's no recommendation at this time, Your Honor. We have not spoken with the complaining witness, although I have made that request. We should hopefully hear something back by today. And I was just letting the court know that he is enhanced. He has previously been convicted of an aggravated sexual assault. And considering this is another first-degree felony, he is facing a lot of time, Your Honor, if convicted.
Okay, can we reset this? Because I don't want to fall through the cracks, number one. Number two, with somebody that has been recently found competent, I don't want him to decompensate. So we need to try to work out this case if it can be done.
Yes, Your Honor.
Okay, Judge.
So tell Mr. Valenzuela, we'll set this up in a week or 2 weeks. I don't know when Ms. Becky can do it. So
Will
I
do,
can
Judge.
give a little push to the DAs, okay?
Okay, will do. I appreciate it. Thank you.
Anything else, Mr. Sebastian Nunez? Did we lose Mr. Sebastian? No? You're okay, Mr. Sebastian?
Yes, yes, you're doing good, Judge.
Okay.
Well, nothing further on this case.
Thank you. David Nunez, anything else?
No, Your Honor.
Thank you. You all may be excused. Have a great day.
Thank you, Judge.
Thank you. The next one was Manuel Garcia, James Dunham, 2018-4083. Announcement of council, please.
David Nunez for the state, Your Honor. State is ready.
Todd Dunham for Mr. Manuel Garcia. We're ready, Your Honor.
And Mr. Manuel Garcia is not with us today, is he, Mr. Dunham?
It does not appear so.
Okay, do you want to waive his appearance, sir?
I was expecting him to be here, but
Well, I'll call the case if you want to try to call him on his cell.
he's
He's in jail. He's in jail, Judge.
Oh, he's in jail, Mr. Dunham. To try to move and if you want me, I can reset this. I only have 2 hours on Friday, right? To access the jail and jail people. You want me to reset this during my 2 hours on a Friday? It's probably.
would that be for tomorrow, Your Honor?
Oh, of course not. Are you kidding me right now? I have not had 3 Fridays. Let me tell you let me tell you a little bit about my life, Mr. Dunham, so that you can feel sorry
Yes,
for
ma'am.
me. I'm going to have a party for 2 minutes. They have given every judge 2 hours weekly to access the jail and the jail people. You know that, right?
Yes, ma'am.
There's been 3 Fridays in the last month and a half that are holidays. So I don't get makeup time. I don't get a makeup day. They said,
Yes,
tough,
Your Honor.
Judge. You get a Friday, tough. You lose your turn. So guess what? I have a list a mile long of defendants that I have to see. So
I understand.
you'll
Well,
put on the list and it'll be mid-July, end of July is what Becky and I talked about.
is Mr. Reese's probation officer on this call
Yeah.
at this hearing?
Yes, I'm here.
Well, I think in the interest of my client, maybe we should proceed because he is in custody and he would like to move things along. And I believe that July he would be upset if he was stuck in there until then.
Okay, sir. So let's go ahead and will you waive his presence then here today?
Yes, ma'am.
Okay, very well. Okay, Mr. Ruiz, you're on. Tell me about the basis of this. Yeah, it's a contested pre-revo hearing. Tell me, what's the basis of this contested?
Yes, Your Honor. Well, right now, Mr. Garcia, he is currently under 24-hour notice for UA testing. On May 6th of this year, I had contacted Mr. Garcia for over the phone reporting. At that time, on that date, he was advised to go for the UA testing, and he understood that he had 24 hours, which he's been on probation for a year now. In checking the results, he had not gone for UA testing. I had attempted to get in contact with him on the 11th of May, the 12th of May, and the 13th of May. I was leaving him voicemails on his cell phone, calling him multiple times in the day. And then on the 14th is when I emailed you, Judge, notifying you that he hadn't gone for the UA testing, and a bench warrant was issued on the 15th of May, and he was picked up on the 21st of May, and he's been in custody since then.
Okay. Can we, you don't think he needs a center, Mr. Dunham? If he's got a drug
Your Honor,
problem,
I apologize. Everything froze up and I didn't hear everything Mr. Ruiz said. Everything on my end froze.
okay, the next time that happens, oh, you can't, okay.
Yeah, I did speak with Mr. Ruiz. My understanding is that this was the first violation of it not appearing for a drug test, and that he hadn't had any prior dirty.
Is this the first time he's been brought, or his behavior's been brought to my attention, Mr. Ruiz?
Correct, Your Honor. This is the first time in which I've had issues. He's gone for drug testing every single week under 24-hour notice up until this point on the 6th of May.
Yeah.
And
I would like to add, although he did not go for the drug testing on the 6th, in checking back on the results, he did go on the 14th of May, in which the results were negative, but of course it wasn't within the 24-hour notice.
Wow.
And Your Honor, did speak with my client. He had lost his phone. He did speak with the probation officer. And the not showing up for the drug test is an issue. I think the other issue is that Mr. Reeves was not able to reach him on the phone. Subsequent to that, he had lost his phone. That was a thinking error on my client's part. He put his work ahead of his probation responsibilities. We discussed that. I also know that he has a good job waiting for him, and that part of the issues are that he needs to get caught up on paying fines and fees. I discussed that with him yesterday, and he does have a job waiting for him, and he would be able to catch up on his responsibilities on the probation end.
Do you know where he works, Mr. Dunham?
I don't have the specific
He works
name.
for JD Abrams. He does manual labor.
Okay, okay.
He's got OSHA approval. He does some equipment work. He works on equipment. His job actually drug tests him randomly as well. So
Good.
he's, in order to keep his job, he has to be drug tested. He understands that I don't believe he has a drug issue. I believe that he just messed up on this one event and then subsequently lost his phone, which compounded his problems. And instead of being responsible and taking care of getting the phone fixed, he put his work ahead of that.
He doesn't have a drug issue and he's on probation for 3 counts of possession. And then he gets
Well,
caught.
I don't believe he currently has a drug issue, Your Honor.
Yeah, he does.
I don't have a prior
Unless he gets
relationship.
major treatment, unless he gets major treatment, therapy, counseling, a major impact happens in his life, he has a drug addiction right now as we speak. He may be able to control it because of work, because of probation, because of whatever, but you just don't get rid of a drug addiction. And you have a problem when you get arrested and put on probation for 3 counts of possession. Plus failure to appear, failure to get UA 3 or 4 or 5 times. Okay, I'm off my soapbox. He does need drug counseling, Mr. Dunham. He does have a problem and he does need counseling. But I don't think this is something that he needs to stay in jail for. Mr. Ruiz, you are very awesome. You are diligent. You are compassionate. You are kind when you have to be, but then you're tough when you have to be too. I think we just need to get him back, put him on probation. I think we got his attention and life is good. And do you see what happens, Mr. Dunham, when you wave somebody's presence? Good things can happen.
Yes, ma'am.
What do you think about that, Mr. Nunez?
Your Honor, I agree with the section 35 days and maybe a little bit outpatient.
We got his attention. Mr. Dunham is going to be set him straight. I'm telling you, Mr. Dunham, he's got a problem. He's going to test positive again, and I'm going to put him in jail. So you need to tell him he needs drug counseling, drug therapy, something.
And Your Honor, I apologize because of the breakup. Could I just hear again what the court's ordering that he do?
Okay. He's going to just go back on probation.
Return to probation with outpatient drug counseling?
Well, I'm not going to order it. It can be ordered. I just, if I put him on tap, Mr. Ruiz, if we put him on tap, he's working for J.D. Abrams. He's probably working 12 to 15 hours a day. When is he going to do groups? When is he going to do individuals? When is he going to go to,
I believe they do have groups at 6 p.m. On certain days, and that's he does get out before then.
In construction?
Correct. He does get out before them because he is able to report to probation.
No, I want to see what this guy does. I want to see what affirmative action he takes, what proactive decisions he makes.
And right now, it is currently done over the phone as well, since there's no face-to-face contact.
What is TAP?
Correct, Your Honor. The counseling.
Okay, how long is the waiting list for TAP?
We would just have to get him screened. I mean, with the urgency, we could probably get him by the beginning of next month.
Okay, Mr. Dunham, I don't want to set him up for failure either. Everything is done on the phone, by phone right now.
Correct.
Okay, that's what TAP is there for, I guess. Let's put him through. Let's put him in TAP. Okay, he's gonna get out, resume probation, get put on TAP. He better make probation a priority, sir.
Yes.
What is speaking loudly and clearly to me in this case is the fact that he's been on probation for well over a year. You said, Mr. Dries, and he was ordered to report weekly with 24 hours notice, and he did that for a good portion of the year, right,
Correct,
Mr.
Your Honor.
Right. And then when he finally decided to go, after begging him for 4 days or 5 days to go, then he goes and it's negative. I think his priorities are all screwed up, Mr. Dunham. I don't think he takes this felony court and my rules seriously. So you need to give him a good little talk.
Yeah, I did discuss that with him yesterday, Your Honor.
Okay, sir. Okay.
And
He's going to be released to streets today.
Yes, Judge.
thank you, Your Honor.
Okay. What else? Anything else, Mr. Dunham?
No, Your Honor, may I be excused?
Absolutely. Mr.
Thank
Nunez?
you, Your Honor.
Yes, sir. Thank you.
Oh, Your
Anything
Honor.
else? Oh, thank you. Jonathan Rivas, that's Matthew Kozik. Court calls cause number 2019-2923. Jonathan Rivas, announcement of council, please.
David Nunez for the state, Your Honor. Stage is ready.
Alfredo Sanchez, Probation Department.
Good. And Mr. Kozik, I let in, didn't I? Mr. Matthew Kozik, are you there?
I see a Matthew James, but he's on mute. He's on mute.
Your
Mr.
Honor, I am present. We're just having a little bit of internet connection over here, but present.
Okay, sir. You are Mr. Matthew Kozik?
Yes, ma'am.
Okay, sir. Your client is in jail. Do you waive his presence?
We do, Your Honor.
Okay, Mr. Alfredo Sanchez, talk to me about what's happening with this case. Why are we trying to revoke his probation?
Your Honor, we're here on a second admonishment hearing. He was admonished back in May 7th, Your Honor. There was an admonishment hearing where he excuse me?
This year?
Through Zoom, Your Honor.
Okay. May 7th, 2020. Okay.
Yeah, we notify you about some positive drug tests. Mr. Rivas was made aware of the consequences about lying to you, and he denied any drug use, Your Honor. You asked him several times if he needed your help, and he said he did not need it. He wanted to do it on his own. You told me to keep an eye on him, and if he ever tested positive again, that we needed to let you know as soon as possible. On May 14th, I called him to do the 24 hours weekly UA, and he did test positive for marijuana.
Wow. So then we issued a bench warrant.
And we notify you, you did requested the bench warrant.
Okay. I think this one needs a center, Mr. Kozik. What are you thinking?
Your Honor, just to note, we've not been provided any of these matters. We were not provided any failed drug tests. We were not provided a basis for the revocation. That is why we filed this morning a motion to quash revocation or whatever this action may be by government. We've not been provided any discovery regarding this. So I believe the appropriate action, Your Honor, would be to quash any action on this absent government providing appropriate notice to the accused, since that hasn't been provided here, Your Honor. If the court is willing to potentially grant a continuance, we don't believe the continuance is warranted here, given the fact that the accused has been detained or in prison since on or about the 9th of June. It has been now 16 days. And again, we've been provided no access or no notice of anything. So we request that you quash any action by government. Now, if it's a court's inclination to put him into some type of treatment, we defer to the court as the best course of action. But we do believe that, as you know, he is entitled to certain due process protection during the proceedings, and he hasn't been afforded those protections during this.
Okay. Let me just explain to you how it works. Sir, did you, are you newly, a new attorney, sir?
No, I'm not, Your Honor.
I don't recognize your name, sir. Have you been in El Paso for a long time?
No, I have not, Your Honor.
Okay, sir. But you are practicing in El Paso now?
Yes, ma'am.
Okay, sir. And your home base is here. You're not an out-of-town attorney, is what I'm trying to get at.
No, ma'am.
Okay, sir. Okay, well, welcome. Welcome, sir. This is a pre-revo hearing. Okay, so it's basically just a status hearing on a revocation.
Perfect, Your Honor.
This is not a contested revocation. The word contested may have confused a little bit, okay? We had to use that word, and Ms. Becky, maybe you don't need to use that word anymore because everything is on Zoom now. and that may have thrown you off a little bit, Mr. Kozik, okay? So I can understand the confusion, and you're new, kind of, I think. I don't know, I can't recognize your face, but I don't recognize your name. Okay, sir. So this is a status hearing on a contested revocation. So at this point, no discovery needs to be given to you. We just very informally discuss what the basis is. You get informed as to what he's done or not done, okay? I get a flavor of the case. I get a history of the defendant on probation. And then I kind of make a little cursory little kind of recommendation as to what I think would probably be in the best interest of this probationer, okay? So all that legal stuff that you talked about is really great and fine and awesome, but in a status hearing, it's not necessary, okay? So I don't want to do, we're not going to go through any legal matters now, especially, I mean, I can't hold any really substantive hearings unless the defendant is present, and I know he's in jail. This is just for us girls to get together, talk about the case, and see what's in the best interest of your client, okay? You understand that, Mr. Kozik?
Acknowledge, Your Honor.
Okay, good. Okay, sir. Now, with that being said, you have the right, of course, you know this, you have the right to proceed with on a contested revo, and you can ask for all that discovery, all that information. You've got a little bit of information now as to what the basis is, okay? Or I'm thinking I want to help and try and rehabilitate your client, and I think, you know, I'm probably one of the only judges that actually say, do you have a drug problem and do you want my help? So I'm still willing to help him in spite of the fact that he rejected me many times, Mr. Sanchez just said that. Even though I offered several times, he's rejecting, but I think he does need a facility. I'll give you the opportunity. He's not here, right? I'll give you the opportunity to speak with him in jail. You can tell him that I think, Mr. Sanchez, do you think a facility is the appropriate thing for this young man?
I mean, we have to get him screened, Your Honor, first, but because he was screened with TAP, Your Honor, and he didn't meet criteria because he has an insurance. But he did mention to the counselor that he asked about how many days he would get in jail because he didn't feel like he needed help and he didn't want to do treatment. So
oh God, that was recent.
The assessment was held on June the 1st, Your Honor.
Ew.
So he still, I mean, believes that he doesn't need the help.
Okay, why don't we do this? Why don't we give Mr. Kozik let's give Mr. Kozik two options. I want to put him in a facility, rehabilitate him, help him with his drug addiction, Mr. Kozik, okay? But it sounds like he may not want that from what Mr. Sanchez is saying. So Mr. Nunez, can you give Mr. Kozik an offer, a time offer? So that
absolutely, Your Honor.
He can go to his client with two options and see what his client says. Is that a good plan, Mr. Kozik?
Yes, Your Honor.
Okay. Okay. So what's an offer to settle?
And Your Honor, just to clarify from what I see, I believe he's only probation on count 1, and it is a Class A. So I would recommend 300 days.
Okay. 300 days El Paso County Jail or facility.
And just to let the court know, Your Honor, no MTA has been filed yet.
It's not. Let's not. I don't want to revoke this young man.
Yes, Your Honor.
I don't want to revoke him. I've been wanting to help him since day one. Okay, but he doesn't want my help. And if he doesn't want my help, let's just let him do time, whatever the time is. Okay, Mr. Kozik, how much time do you need? I will set up another pre-revo hearing. Okay. Where
Your Honor, I've spoken with the accused or Mr. Rivas on this matter many times, and I do believe the appropriate way forward is treatment facility, Your Honor, based on my conversations with him.
Good. I hope so, Mr. Kozik. But you know what? You can want it. I can want it. But do you think he's open to it? Yeah. Have you talked him into it that he does need help? He's open to
I do believe, but again, I will speak with him this afternoon. And if we need to set something up,
And let me tell you, Mr. Kozik, let me give you some more information. Is that if he agrees, we don't even need another hearing. Just contact Mr. Nunez, tell Mr. Nunez he's agreed to a facility. Then you guys inform me. I will inform Mr. Sanchez, or you could go directly to Mr. Sanchez, and Mr. Sanchez just does the mods. And then once the mods are done, he's put on the list. That's what we have to hurry up and do, so we minimize his time in jail. He's put on the list, and I don't know what the waiting list looks like right now. I'm sure it's kind of scary, but he's put on the waiting list as soon as we get the mods done, okay? So contact me and contact Mr. Sanchez, and then he's just put on the list, and we just wait, and hopefully he'll get the help he needs. Okay? So will you call back and let us know then, or are you telling us right now he's agreed to a facility and just do the mods right now? You know that? Mr. Kozik?
John, I'll call back by the end of today, just to verify.
Okay, sir. Very good. Very good, sir. Anything else, Mr. Kozik?
Not from defense, Your Honor.
And Mr. Kozik, next time I want you to participate by video. I don't think I've ever met you personally, have I? I don't remember the name.
Ma'am, you have not. We had some issues with the camera. That's why we're doing it on this.
Okay.
It's a little blurry. That's why.
Okay, sir. No worries. Next time, practice. Practice next time so I can meet you at least through Zoom. Okay, Mr. Kozik?
Yes, ma'am.
Mr.
Thank you,
Nunez?
ma'am.
Yes, sir. Anything else, Mr. Nunez?
No, Your Honor.
Thank you. You all may be excused. Have a great day.
Thank you, Judge.
Okay, the next one is Jennifer Acosta, Mr. Joshua Spencer, court calls cause number 2019-3438. Jennifer Acosta, announce on the council, please.
David Nunez for the state, Your Honor. The state is ready.
Good morning, Your Honor. Joshua Spencer, behalf of Ms. Acosta, and Ms. Acosta is on Zoom.
Is present. Ms. Acosta, how are you?
Good, how are you?
I'm good. Ms. Acosta, do you see and recognize your attorney on the screen as your attorney?
Yes, ma'am, I do.
Okay, and Mr. Spencer, do you see and recognize your client as the defendant in this case?
Yes, Your Honor.
Very well. Let the record reflect that both have recognized each other. Ms. Acosta, I'm just a little bit concerned. Let me read to you the email that I got, and then I'm concerned because I think you were a bit disrespectful in the emails and in the correspondence that you had with your PR bond officer, okay? I received a lockout notification from Ms. Jennifer Acosta advising me her unit went into lockout on 6/10/20 at 5 p.m. What was originally thought to have been an issue with payment was discovered to be a failure to physically service the unit on time. The lockout has caused her a number of missed and late tests to be a total of 7 missed and 4 late tests in the last 30 days, and will increase if the unit is not serviced before 5 p.m. today. The defendant has argued that she is not at fault for any of these issues. I've attached the full correspondence between myself and the defendant for your review at your earliest convenience. I don't want to waste everybody's time, but the emails were basically, this is ridiculous. I really don't have to do it. I'm a very busy person. I don't understand why I have to do it. This is ridiculous. Everything is ridiculous. The system is ridiculous. She used ridiculous about 10 times, Mr. Spencer. And I could go through the string of emails if you want me to, but I thought that was a bit disrespectful of the PR bond, a disrespect to me, a disrespect to the system, because a felony court, terms and conditions of a PR bond, there's nothing ridiculous about that. It's all serious. It's all pretty serious. You know my zero tolerance, Mr. Spencer. I have about no alcohol monitoring device on a DWI 3rd or more. I just have a zero tolerance. I just want some explanations, I guess, or some.
Your Honor, thank you, Judge. And Ms. Acosta, we did talk about it, and she recognized that she anticipated that this was going to be an issue. And I talked to Ms. Acosta. I'll tell you right now, Judge, in about an hour, Ms. Acosta is about to take her final exam, and for her nursing. And as she's part of her, she basically on the front lines working at the hospital. I mean, she's kind of, strung out, a little bit of pressure from work. She's got this pressure from this case that's really weighing on her. And the length of this case is really how can I make an excuse, Judge? And that's basically what I'm doing. It's not a justification. It is an excuse for Ms. Acosta, because I think during these times with her work, with her education, with this case, plus for pending the decision from the Court of Appeals, that's going to kind of define the issue for Your Honor to decide, which is going to be material on how this case is going to, the road this case is going to go. But Judge, as a voice for my client, it just, she's going through some stressful times, as we all are. I think she really feels it now. And I can tell you, Judge, I'm sure she has good intentions, but there are better adjectives to use than ridiculous. And so that, I think she's willing to accept responsibility for that. I don't expect this to be a problem. I definitely know that you have her attention. I've explained to her the zero tolerance in your court. And so I don't expect this to be an issue with probation. But with God willing, that with these machines, I mean, they break, they need service, they need to get fixed, they don't need to get fixed. So it's just something that I just explained to her that she needs to manage better and communicate with different words.
Right. Number one, who's the one that got DWI third or more arrested? Acosta, Ms. Acosta, who's created this situation?
You're correct, Your Honor. You are correct.
Okay.
May I speak?
If your attorney lets you, absolutely.
I just wanted to let you know that, the day that all of that was happening with my PR bond officer, I'm in surgeries all day long, and I work at the hospital all day long. And when I got that lockout notice, I was a bit upset because I was not informed that my device had to be serviced after a year. And then it happened to me last month as well. And I had already gotten it serviced, and they locked it out again this past month. So those are neither my fault. I have complied with the device over a year now and have not had any issues. As far as anything else is concerned, maybe I was a little disrespectful. And as I said before, I go to a hospital every day and deal with COVID patients on a daily basis. And all of it is just, starting to add up now, I guess. But I apologize for my disrespectful emails to her. But I was upset because neither one of them was my fault. And the second time that it got locked out, it shouldn't have been locked out because the previous month I did get it serviced, and all of that is noted in Smart Start. So like I said, I have not had any issues with my device. I've complied for over a year now, and I'm just a little on edge these days. And that's due to my schooling and being in a hospital doing my clinical rotations. So it's getting better now, thank goodness. But like I said, I have not had any issues with my device for over a year and a half until these technical issues have been happening, not because I've blown positive or because, yes, late because I'm either exhausted, but I'm going through finals and I have to pass a state test to become a radiographer, and it's just become a lot. But as I said, I apologize for the disrespectful email.
Well, I think go ahead. Go ahead.
Thank you, Judge. Thank you, Judge. And really just to let the court know, I mean, with Ms. Acosta, I think she's being candid with the court. And I don't think she's saying anything that's not true. But just to highlight, Judge, that these machines are not perfect, and so we just, and all I'm asking, Your Honor, is just that, just as a note, with these Smart Start machines, obviously she's got to use it. Obviously it's a condition of the court. But as an attorney who practices throughout the state of Texas and New Mexico and different courts, different district courts, it is always a constant battle for the defense to show that these machines are not perfect and not 100%, and they do malfunction more often than we want them to.
Right, right. In this particular case, though, she didn't go get it calibrated, and
Right.
that's why it malfunctioned. Now, she's saying that is her responsibility. She's saying she didn't know and nobody explained to her. Okay, I'll buy that. But now, Ms. Acosta, you know that you got to calibrate it. I don't know how many times. I have no clue.
Well, see, that's, Your Honor, that's the thing is that
Ms. Acosta,
nobody. Yes, sir.
Let the judge finish. I'm sorry.
Okay.
Yeah. So I will buy that story that you didn't know, Ms. Acosta. I'll buy that. Then to add on top of that, the fact that you are a health care provider, you are our warriors and our soldiers on the front line. I really honor that, respect that, appreciate that. Most important, I appreciate the apology that you gave today for what happened, okay? We are all going through stressful times. And I think if we realize, take personal responsibility for our actions and apologize, we would have a much kinder, gentler nation. So I appreciate that. I think I got your attention. Just make sure you know now your times and dates for calibration. I appreciate the fact that you've never tested positive, really. We've never had a problem. So I'm okay. Just be sure I got your attention. Just respect us all a little bit more, and you've apologized and we're all good. And I think you need to get back to work. Okay, so
Yes,
this isn't going to happen again. I can see, I have a crystal ball on this one. This is not going to happen again, and good luck on your exams. And thank you for fighting this coronavirus ugly war. Thank you.
Thank you so much.
Okay, Mr.
Appreciate
Spencer. Yes, ma'am. Anything else, Mr. Spencer?
Nothing further, Your Honor. Thank you, Judge.
Anything else, Mr. Nunez?
No, Your Honor.
Thank you. You all may be excused. Thank you. Okay, Christine Perez, court calls cause number 2017-0602. Christina Perez, announcement of council, please.
Yes, Your Honor. ADA Alyssa Nava for the state of Texas, and the state is ready to proceed.
Okay.
David Smith for the defendant, Your Honor. We're ready. And
Okay.
Mr. Pettis is here.
Okay, good. Okay. I think so. There may be some reverberation coming from you. Is Miss
Judge,
Perez?
I think it was coming from Ms. Perez, but she went ahead and put her phone on mute, so we're not getting it anymore.
Okay, we're good. But Miss Perez, I see Miss Perez on the screen. Miss Perez, you need to unmute.
Well,
Yes, ma'am.
Do you see and recognize your attorney on the screen?
Yes.
Okay,
we're sitting
mute,
across from each other, Your Honor.
mute back up again because I don't want any noise, Miss Perez. Thank you. H. Davidson, you're there with her, right?
Right.
Okay, very well. Now, this is as to a rec. Do we have a rec in this case, Ms. Nava?
Your Honor, what was going to happen was Mr. Smith was going to get me documentation after serving as probation.
Hang on.
That one's coming from David. That one's coming from David.
Turn that thing off.
How far is
Put on
Miss
mute.
Perez?
Just turn it off. Turn it off.
No, Mr. Smith, you can't be on mute. I have to talk to you.
No, I'm not on mute.
I know. I have to talk to you.
Well, I'm going to bring Mr. Pettis. Turn it off. Get over here.
Okay.
See how simple that is? Come on.
Yeah, good. Okay, there you
I mean,
go.
you know.
Yeah, you have to. I think it's getting from there. Okay. You were supposed to prepare a probation packet, I think is what I heard Ms. Nava say.
Which he did. He provided it to me Tuesday afternoon. I've reviewed it. I just need to make sure that I need to contact and confirm everybody that he provided that from. I don't think there's going to be any issues with that, but based on what he has provided, I believe I am going to offer probation. I just need to confirm with the people who provided those letters.
Hey, you did a good job, Mr. H. Davidson Smith, in convincing Ms. Nava. That's awesome.
Well,
and
she's
Nava, you're being very reasonable. That's awesome as well.
well, she's a prosecutor of the heart, Your Honor.
Exactly. Thank you both. Thank you both for that. So do we need to set this up for another settlement conference? You think you can work out a plea and then you call Ms. Becky to set it up for a plea, Mr. H. Davidson?
Probably the plea, Your Honor.
Okay.
You know, why do two things? We can do it once.
So why don't we just set this up for a plea like in 45 days? That gives you plenty of time to work it out.
Does indeed.
Yes, Your Honor.
Plea in 45 days. Remember, this is a non-custodial in-person plea. So it could really take longer than that to have this. They're not letting us do any in-person right now at this time. Okay, so we'll put it on the list, but continue to work something out, okay?
We
Yes, Your
will.
Honor.
Thank you.
Thank you. You all may be excused. Have a great day.
Thank you, you too,
Okay.
Your Honor.
Thank you. Boca Negra, 2017-1118, Boca Negra, announcement of council.
Ivan Martinez for the state.
Eduardo Miranda for the defendant, Renny.
Now, this has been going round and round for years.
Judge, Mr. Bocanegra is on also, but he's on mute.
Oh, Mr. Bocanegra, where are you, sir? Can you unmute Mr. Bocanegra?
He's on mute still. He's waving, but he's still on mute.
Can you unmute? I'm asking you to unmute, Mr. Bocanegra. Mr. Bocanegra.
He just did it. He just unmuted.
But okay, sir, do you see, Mr. Bocanegra, do you see and recognize your attorney, Mr. Miranda, on the screen?
Yes.
Very good. And Mr. Miranda, do you see and recognize Mr. Bocanegra as the defendant and your client in this case?
I do, Your Honor. I don't recognize the ADA Martinez without that facial hair, Your Honor, so.
That's ADA Martinez. Let me see, Mr. ADA Martinez, how much facial hair?
I'm also known as the prosecutor with the heart, Your Honor.
That was Miss Nava. That was Miss Nava. That wasn't you, Mr. Martinez. Okay, this case has been going round and round. The last time I think we spoke about a deposition. Is that my recollection?
Yes, Your Honor. That's correct.
What are we gonna do now?
Well, Judge, I emailed you and the defense counsel a little package. I don't know if you received that on Monday or Tuesday.
I think I did. Yeah. Now I received it. I saw it, but honestly, I'll put myself in jail for 30 days. I haven't read it.
Well, there you go. But the gist of it, Your Honor, is okay. I know we've talked about this case, God, probably a dozen times now. But the gist of it is that we're alleging assault enhanced, right? Within believe it's a 30-day period. So there's only one police report, right? And while they're investigating one alleged assault family violence, they speak with the complaining witness and they take a video of her. And in that video, she says that a few weeks before he assaulted her as well. And what I did was I emailed you both my motion to reconsider, and what we had done was we did the video interview is in Spanish, so we translated that into English, and we did the whole notice of filing translation, 45 days in advance of trial. So we filed that about a year ago, and I just gave that to you so you could have a chance to read the transcript of what she alleges, and of course this is nothing new, but my position is that that puts the defense on notice. What she says in that interview puts the defense on notice as to what the allegations are. So that's
Okay, let me ask a question. Does she say it happened 3 weeks ago? It was September the 5th, and we just came home from eating at a restaurant, and then he did this, and then I said this, and then it happened? Or at least September the 5th, at least, Mr. Martinez, does it say on September the 5th, he beat the crap out of
let me see here. I don't remember off the top of my head what exactly she says. Let me get the transcript. Let me pull it up now.
He just makes a general reference, and the same thing happened about 3 weeks ago.
Let me see. I can read it now. It's towards the end. Let me see if I can find the relevant portion here.
Judge, while Mr. Martinez is doing that, my recollection of the transcript is that all she says was, and this happened also 3 weeks ago, and that was it.
See?
The September 5 date is something that the DA's office came up with.
Okay.
And so we've been back and forth on this. The last time we were in court, the judge, you ordered that a deposition be allowed because we showed good reason. So we were on the verge of setting up a deposition when Mr. Martinez filed his motion for reconsideration. Then we entered the COVID-19 pandemic.
Right.
And so that put everything on hold.
That's
Now, we want to go forward with the deposition. We'll have to do it remotely
Right.
because of the COVID. And then depending on what happens at the depot, we need to probably set it for some type of jury trial sometime next year. I've got some underlying medical conditions, and because of my age, I'm real concerned about contracting COVID anytime soon, Judge.
Of course.
So that's what the status of the case is.
Okay. Okay.
I found the portion, needless to say, I don't think a deposition is necessary, but let me read you the relevant portion here.
Read it to me.
It's apparently, it's an interview between the complaining witness, her name is Claudia Lopez, and Officer Castaneda. And then, at the first portion of the interview, basically, it's a back and forth describing what happened on the date of the incident, okay? But then at the end, this is all in Spanish, so I'm gonna read you the English translation.
Okay.
Officer Castaneda asks, "Is this the first time that he hits you?" And then Ms. Lopez says, "No, it's been several times." And then Officer Castaneda, "Tell me about some other times that it happened." And then Ms. Lopez says, "The last time was about 3 weeks ago. He left some bruises here on the elbow, on the legs. Actually, I have some pictures, but they told me, but they're not good anymore. But that also on the butt because he hit me with his hand." And then that's the end of it. Then the officer asks, "Are you afraid of him?" And she says yes, but that is the one portion when she talks about, and needless to say, he's correct. She doesn't say that this happened on the 5th. She just says that it happened about 3 weeks before. And if you look at the dates of this incident and about 3 weeks before, it's more or less the 5th. And we've talked about this before as to the specificity required in an indictment when we're talking about an on or about date. So the specificity is there. Needless to say, this is alleged to have occurred before the case was indicted. So the on or about specificity is there. So that is the allegation, Your Honor, that she says that he hit her with his hand on her butt, on the elbow, and on the legs.
But at least at best a date should be.
Well, that's what I'm saying, Your Honor. She says about 3 weeks ago, the last time that he assaulted me before this incident that the officer was there to investigate was about 3 weeks ago. And that's the date, more or less. That's the date that we've chosen is the 5th. That is, and I, needless to say, I sent the case law to you and then defense counsel, talking about the specificity required in order to prepare for trial. And that's it. That's the allegation. It's a valid indictment. It puts the defendant on notice as to what he's being charged with and the on or about date. And I think in addition to that indictment, you talk about this video interview, and he has access to the actual video, of course, not just this transcript. And I think that puts him on notice as to what. And that's the thing, Your Honor, is, and we've talked about this before as well. That's all the specificity that I have as well, is that I will prove that sometime about 3 weeks before, the defendant hit her on her butt, legs, and elbow using his hand.
And there's pictures of that incident. She said she had pictures of that incident.
Judge, she said she had pictures of the incident.
So he's not entitled to.
No, the pictures don't exist anymore. She told the officer that she was told those pictures weren't good anymore. So as far as I know, there are no pictures of the previous incident.
What happened?
This is a criminal case. And so we don't know the where, what's, and whens of that previous incident so that we can prepare. And the court already found good reason to take the deposition.
What happened to the pictures, Mr.? There's no
well,
pictures.
there are some pictures. There are some pictures that are in this case. the present case, the case that they were investigating.
She told the officer, I have pictures of the one 3 weeks ago.
There's that. I haven't spoken with the complaining witness about the, whether or not there are photos documenting this alleged previous incident. I've never done that. I'm sorry.
She said, she told the police officer there's pictures.
Right. Yes, that's true. That's what she says. But whether or not she still has these pictures, I don't know. And I apologize. I've never inquired as to the existence of those particular photos. But like I said, Your Honor, if they exist, certainly I'll turn them over to the defense. But what I'm saying is, even if they don't exist, that's neither here nor there as to the notice. That's something for the defense to bring out in trial. Hey, if these injuries are so bad, how can you even take a picture? Okay, well, that's something you can bring out in trial. But that doesn't go towards, putting him on notice in preparation for trial.
But it could be to properly defend the case. Okay, you've given enough notice in an indictment, so it's not subject to a motion to quash, but at least some kind of specificity, i.e. there could be an alibi situation. And 3 weeks ago, well, pinpoint, give me a little bit more detail, a little bit more time so that he can defend, prepare and defend. So it doesn't have much to do with notice, but it has to do with properly defending a case. And with nebulous kind of allegations like that.
Well, Judge, I mean, if he has an alibi, hey, you know what? 3 weeks before that, she had come at me with a frying pan, okay.
Yeah, but we don't even know the date. We don't even know the date she's talking about.
No, Judge, and she may not herself.
Okay.
She may not be able to say, yeah, it was on the 4th. It was around 9:30 p.m.
Right. She might not.
What I'm saying is, she just says, yeah, it was about 3 weeks ago. If that is the case, if he can remember, hey, you know what, her boyfriend came in and attacked me that day, and she was ganging up on me, and the two of them were beating me up that day. Okay, then that's fine. I mean, he can prepare for that right now. He knows if there is some incident where there's extenuating circumstances, or he has an explanation as to why she may have bruises on her, or you know what, about 3 weeks before that, she was in a car accident. He knows that. It has nothing to do with deposing her.
We need to explore the factual basis of her allegations. We don't know if this came all about as a result of some rough sex or something. I mean, we just don't know the factual basis of the allegations.
The rough sex with a client or somebody else? Mr. Miranda?
I'm sorry, Judge?
You don't have to answer that question. This is my next question to you. How do you know that those photographs don't exist right now?
Because I haven't seen them in the file, Judge.
Oh,
the police did not collect those photos, Your Honor. They did not. The police did not collect those photos, and it's for right now, the only thing that's in that file is the police investigation. I can call her and ask her, hey, do you have photos from this incident?
Because you know what? Those photos, I didn't realize that there were alleged. Those photos may give a date. If it was taken on a cell phone, whatever, they'll give a date, and in which case I think that should be sufficient, and we're good. Then no depot. Yes, if pictures exist and show a date, that's all, that's what he needs to know.
Judge, and I will reach out to her, and I will try and figure out, hey, you know what? I remember it was the night that we had gone to Chico's Tacos or whatever. You know what I mean? Just to see if she can, remember, and hopefully that'll, give the defense counsel, more of an opportunity to try and figure out if there's any defense issues that occurred that day.
Extra, but I just want to see if there's pictures and dates, because I thought the date was really important in this case. 3 weeks
Judge,
ago,
could we possibly reset this for, let's say, 60 days to give Mr. Martinez an opportunity to locate those photographs? I'll postpone the deposition for now.
Yes. 30 days. 30 days.
30 days, okay.
30-day settlement. Thank you. You may be excused, Mr. Miranda.
Judge, and just to be clear,
Stay safe.
you haven't made a final ruling one way or another on this deposition thing. Okay.
No.
Okay.
He's
All
holding
right.
it.
Well, I will reach out to the complaining witness and I'll try and see if there's some evidence or photos or something that can try and give us a little more guidance here.
Perfect. Thank you.
Thank you, Judge.
Thank you all. You may be. Stay safe. Thank you, Mr. Miranda. Yes, sir. Yes. Thank you. Next one is.
But the court did make a final ruling, but it's subject to a motion for reconsideration. So that's where we are.
We are in the motion to reconsider. Yes, sir. And I've reconsidered. I've set aside the order until we can see if there's dates on those photos.
Very good. Okay.
Thank you. You may
Thank
be.
you, Judge.
Have a great day, Mr. Bocanegra. Thank you, sir. You may be excused.
Thank you.
The next one is Ricardo Morales. Is Mr. Avelar on? We don't have Mr. Avelar on, do we? Mr. Salazar? Or Mr. Wyatt, right?
No, I don't see either of them on, Judge.
Okay, Mr. Montoya, Alberto Sandoval, court cause number 2019-5643, and ask from the council, please.
David Nunez for the state, Your Honor. State is ready.
Roger Montoya for the defendant. I'm ready to proceed.
Very good. Is Mr. Sandoval participating with us today, Mr. Montoya?
No, Your Honor. I think that the court might recall that the last time that we were here, I had lost contact with my client. I had made every effort to try to contact him by way of the contact point that I had, which was his grandmother. And I have not heard back.
And PR Bond has lost contact with him too. He's not compliant with his PR bond either. I'm going to go ahead and revoke his PR bond, Mr. Montoya. Okay. I don't think I have any choice at all. They've lost him since, oh God, he's not reported since March, Mr. So he's not gonna make contact with you. I don't think, if he's not compliant with his PR. Mr. Salazar, let's just revoke his PR bond.
I'll let Rita know right now, Judge.
Please.
Your Honor, there is a separate, another theft case with a different cause number that's also indicted in this court. So we reschedule it. First thing,
Give it to me. Give it to, so Ms. Becky can put those two together.
Yes, Your Honor, I'll pull it up right now.
Please. Okay, Mr. Montoya, are you appointed on that new case, or are you retained in this case, or what, Mr. Montoya? Talk to me.
I'm appointed, Your Honor, and I think I remember receiving an order appointing in the newest case pre-indictment, but I'll double check my records.
Mr. Bocanegra wants to come in again. Mr. Rick, I'm going to let him in, but tell him he can leave, or I'll try to tell him. Okay, Mr. What's the cause number, Mr. Nunez?
Yes, Your Honor. The cause number is 2019-0D03315.
Did you get that, Miss Becky? Miss Becky?
Yes, Judge. I wrote it
down. Okay, thank you. Thank you, Miss Becky. Okay, we're good. Okay, once he gets arrested, I hope we can appoint you, or you're appointed on both cases, is what you said, Mr. Montoya, right?
Yes, Your Honor.
We'll just wait until he gets arrested. Hopefully it'll be soon. Anything else, Mr. Montoya, in this case?
No, Your Honor. Thank you. I'm sorry I took a second to think about that.
That was a funny face, Mr. Montoya. Thank you, sir. Mr.
Yes, Your Honor.
Yes.
May I be excused?
Absolutely. Thank you so much.
Okay. Bye. Bye.
Okay. Thank you. Bye, Mr. Montoya. Have a great life. Okay. I'm back
Thank
to the docket at the very beginning. Mass check. Is everybody there for mass check, public defender? Miss Becky, can you?
I'm here. I'm here, Your Honor.
Okay, great. At this time, court calls cause number 2019-1288, Adam mass check, and ask from the council, please.
David Nunez for the state, Your Honor. State is ready.
And Felix Castaner for Mr. Maschek. Your Honor, I would ask if I could waive his presence. He's in jail.
Absolutely. Absolutely. The issue was, and Ms. Alanis?
Yes, Sandra Alanis with adult probation.
We wanted to send him to safety as we wanted to do, Mr. Castañon. What are you feeling about that?
Your Honor, first of all, I'd like to apologize. I was in the 210, so I apologize for the delay. I did talk to him a while back, and we had a long discussion, and the options presented were either 7 TDC or SafeP. And he did say that he would agree to SafeP, and so I told him that at some point his probation officer would present him with some modifications, and I advised him that as far as I knew, they was going to be modified to SafeP, and so he was okay with it.
Perfect. That's beautiful. Let's do it, Ms. Alanis. Yes?
Yes, Your Honor.
Perfect. That's awesome. Hopefully we'll get through to these two young men, David
Yes, Your
Henry
Honor.
and Matt Chick too. Hopefully.
Yes, Your
Let's
Honor.
pray for that. Good, Mr. Castañon. That's excellent news. Submit the mods, please, Ms. Alanis. You all may be excused. Have a great day.
Thank you, Your Honor.
Thank you.
Thank you. Portfolio recovery versus Enrique Tuca. What is happening with that one, Mr. Linzer? You're present. 2018 DCV 25. Announcement of council, please.
Chase Linzer for the plaintiff portfolio recovery.
Good. Okay, sir. Now, this was settled last week. This was set last week, but what did we do, Miss Becky? We reset it this week. Case settled. Do we have an agreed judgment filed, Miss Joanne? in this-
I have been trying to reach out to the defendant. I've given him a couple calls. I have not heard anything back from him. We do have an agreed judgment and a settlement agreement in place. He's been making payments on it, but he's never sent the signed copies back to us. So, I mean, at this point, I think our only option is to move forward with a default judgment. I mean, I don't want to, just because he has been paying under this agreement that we've sent to him. He's just never sent us a signed copy of the settlement agreement and his signature agreeing to an agreed judgment. He's paid about $5,000 already.
How much does he owe remaining? What's the balance remaining?
The balance remaining is $5,614.54.
You can't find him?
Oh, we have an address for him. We don't have an email address to contact him through email, so we have to send everything by mail to him. But we also have a phone number, and I've called the phone number several times, but I haven't received a phone call back.
Wow. Okay.
But like I said, he's making payments on
I
the
know.
payment plan.
That's why I think it's ugly to do a default on somebody who's making payments.
I mean, I think it's horrible too, Your Honor. Like I don't want to do it. Maybe we can set it for trial, maybe, and we can get a hearing sent to him.
Are you there, Judge? It looks like she dropped out.
Oh no.
She'll get on right now.
Okay. We'll wait for her to come back.
You're on mute. There you go.
Yes, thank you. Okay, something's up with my internet. Okay. Mr. Linser, I just stopped with, I think it's ugly to default somebody that's living by the agreement. See, this is what happens when attorneys are remiss and don't file the documentation quickly and don't do, and then it just, you know.
I understand, Your Honor. I agree with you. I think it is, you know, it would be unkind of us to file a default for him because I mean, like I said, he's
Now,
already paid like $6,000.
and this is what you're going to have to do, please. The only thing that'll soothe my heart is you're going to write him a letter. You're going to call him. You're going to leave no email. You don't have an email on him. You're going to leave voice messages that basically says, you need to sign this agreed judgment. If you don't, a default is going to be entered.
Okay,
Maybe
Your Honor.
that'll scare him into signing the default, and then, or he'll call us or call you. Or call somebody. He won't be missing an action. When he makes the payment, he does it by check. Is there information on the check?
I'll have to look through it and see if there's any pictures. We usually don't take pictures of the check and put them on file, but we do have the confirmation number of the receipt that has been sent in. But it seems like he's been making payments online, so he does have some sort of internet access. We just don't have an email address for him.
Okay. Well, I think I'm going to give you a little bit of time to do by May, to just inform him. You're going to have to show me documentation for me to proceed to a default. He's not filed an answer, Miss Joanne? See,
No,
that's
Your
the
Honor, he has
other
not.
thing. I don't think legally you can proceed to a default.
That I had my reservations about it too, because I mean, technically he has responded to the suit with us. He just hasn't filed a proper one with the court.
Legally, you can. I'm thinking this through. You can't proceed through a default.
And Judge, the citation was issued and it was served, so they still have an address that they can notify him by mail too.
No, he does have an address. He says he has an address.
Because if I do anything, I would have to send it certified mail, but because he's answered, I wouldn't
What
send.
I'm saying is, if, oh, he's paying online, so you have no information. Yeah, Miss Becky, he said he has a physical address. He does have one. Okay, Mr. Linser, you guys created this problem. You guys have to solve it.
I will get it done for you, Judge.
Thank you, sir. Thank you. Let's set this up for, let's give him 3 weeks and see what you've done. If you've sent him certified, send certified as well as, and you know what you need to do? Maybe you can give him the Zoom invite too. Tell him to sign the agreed judgment or participate in this Zoom hearing in 3 weeks for any issues you might have, right? He may feel a little bit hesitant and intimidated about signing a default, an agreed judgment. But if he's on Zoom, we can explain to him what we're doing.
Right.
Okay. So Ms. Becky, give him a hearing in 3 weeks. Do Zoom. I want you to send him all the Zoom invite information. We're going to provide it to you, Mr. Linser. Okay.
Sounds wonderful, Judge.
Show me all the efforts you made. Keep use due diligence to try to, and then prove it to me at the hearing, and then we'll see what we can do. I don't think it's I think the only thing I can do at this point is dismiss the case.
Okay.
That's the only thing I can do. I don't think you can proceed to a default because he's somewhere because he's making payments.
Okay. Like I said, I will do my best to get in contact with him, and hopefully we can get that agreed judgment signed and sent to you
That's the
best. Next hearing.
That's the best resolution. That's the best. Okay. Settlement conference in about 3 weeks. You know what? Let me give you 30 days because certified return receipt takes a while and all of that, right? Let's do at least 30 days. Okay, Mr. Linser, thank you, sir. And thank you for your patience this morning. You may be excused, sir. Thank you.
Honor, you have a great rest of your day, a great weekend.
You, sir. Be safe. Thank you, sir.
Thank you. You too.
Maybe excuse, Judge?
Is that you, Miss Joanne?
Yes, it is.
Yes, ma'am. Yes, ma'am. Thank you.
Thank you. Have a good day.
You too. Ricardo Morales is the next one. Is Mr. Avelar back or not?
And if he's not, Judge, I called and they told me that he had a hearing in CC2, and as soon as he was done, he was gonna get on.
Okay, well, I think I'm done. And I'm not gonna be on waiting.
Since his client's in jail, do you want to bring it up at 1 o'clock?
Yeah, tell him to join. Tell him to join at 1 o'clock. We're not gonna sit here and be waiting for him. It's already 9, 10, 11. Yeah, he's already an hour and 40 minutes late.
Okay, so I'll call his office and tell him just to join in at the 1 o'clock invite.
Because I'm closing this one.
Okay, Judge.
We're done, right? Mr. Rick, Miss Becky, we're
Yeah.
done.
Yes.
Yeah. I'm not gonna hold Miss Anita here just for Mr. Avelar. Thank you, Miss Anita. We see you at 1.
Okay, Judge.
Yes, ma'am. We'll see you later.
Thank you, Mr. Lopez. We're good.
We're still on YouTube.
Oh, let me get off. Thank you. I forgot, Mr. Rick. Thank you guys for reminding me. We're good. Thank you. Everybody stay